Yes.
My Lord, my Lady, I had reached section 5 of my submissions to the authorities. Just to flag up at the beginning, there's really one main point of principle that I draw from the authorities, which may or may not be terribly controversial, and that's this. The discretion is one to correct an injustice, to, in my phrasing, close the gap between what the duties one has ended up being owed and the duties that one should have been owed had the local authority acted lawfully. And I say that therefore that therefore applies to both a gap between former relevant child duties and no duties at all, which is established in previous cases, and to the gap between former relevant child duties and the lesser qualifying young person duties. And that's not seen from previous cases.
That's a new proposition.
It's a new proposition, but
you say not much of an extension.
It's an application of the same principle.
Logically, it must apply.
Absolutely.
If you're right.
Yes, because it's an application, indeed, of a yet broader principle, which I'll show you.
So you would say it was it's a lesser difference.
Yes.
So it must be encompassed by the wider difference.
Yes, the injustice is smaller, but
if it covers the injustice between a former and nothing at all, then you say it would follow that it covers the distance between a former and a qualifying.
Yes, I mean that wasn't how I phrased it in my own mind, but that would be another way of.
No, I'm just
is that
getting it down to brass tacks. Okay, so you say the authorities go to the first of those propositions.
Yes, and in my submission support my extension.
Yeah.
So GE Eritrea, Volume 2 of the authorities, tab 19 for those who have, and page 370 for those who don't. And the first thing to note is that this, and indeed HP, which I'll show you in a moment, are about a different situation again, because these are cases where someone was age assessed not to be a child, and then challenged that age assessment, and the injustice arose from the fact that they were assessed as being an adult rather than a child who was assessed not to have needs. So it's a further type of category. The key passage is the sideline passage. I invite your Lordship and your Lady to read the headnote at some stage. I think probably for reasons of time I'll go straight to the key passage, which is paragraphs 52 to 55 of Lord Justice Christopher Clark's judgment at 384 to 385 of the bundle. And the key point for my purposes is that at 54, His Lordship says, I accept that local authority may use its discretionary powers to make good any unlawfulness that it has committed in the past, and may, in some circumstances, be obliged to do so. And then the authority cited for that proposition is the case of Eston, the Secretary of State for the Home Department, which is one about grant of leave to remain. So what I draw from that is that the application in Section 20 cases is in fact an application of a broader public law principle, and that I pray in aid of my submission that it should then therefore apply to other categories of injustice within Section 20. And for your note, Lord Justice Davis at paragraph 96 makes a similar point, again citing S, but talking about other cases where a public body may be called on to consider correcting a historic injustice.
Yep.
While we're on GE, it's also worth noting at 71 to 73, page 388, the treatment of 2 points made by the local authority in that case. I should say it's titled GE Eritrea and the Secretary of State for the Home Department. It was actually the Secretary of State and Bedford County Council. and so Mr Greatorex was acting for the council. 71, his lordship says, Mr Greatorex pointed out, and this goes to a point raised by Surrey in the present case, which I'll get to in the final section, pointed out that no application had been made for the local authority to exercise any such discretion, nor had there been any material response to the point made in his skeleton that it was not clear what support or assistance might have provided. Mr Southey's response for GE was that since the local authority does not accept the claimant as a child, any request on her part would have been likely to be met by the assertion that in light of her true age, no discretion felt to be exercised. Given that the question of discretion is likely to be academic unless the claimant succeeds on the age assessment question, and given that the application notice clearly sought a declaration she was under 18, I don't think it would be right to refuse relief on this ground. So I'll refer back to this when I come to my learned friend's case. And then 72, you see the authority's submission that it would impose an unacceptable burden on local authorities to operate some quasi-ombudsman-like scheme of review of past wrongful decisions. And then at 73, you have, while I see the force in the submissions, doesn't seem right in principle to rule out the need to consider any remedy for past breaches of duty. Parliament chose to confer an entitlement to important rights on those who were in fact children at the relevant time. If, as it turns out, they've been wrongly deprived of that entitlement, the possible need to remedy an injustice should be addressed. And I say that that same reasoning, that Parliament has decided to confer an entitlement to former relevant child duties, applies where what you've ended up with is qualifying young person duties instead. So leaving GE and moving then to HP and Greenwich, which is still in volume 2, tab 27, page 585. Again, it might be useful to look at the head note in due course for your own purposes. But again, this was a case concerning an incorrect age assessment, successfully challenged before the upper tribunal, and then the local authority refused to exercise the discretion on the basis that it hadn't been culpable in finding that HP was an adult, not having had the benefit at that stage of the evidence that was before the upper tribunal. If I could ask...
There's 3 pages of closely typed head note.
Yes.
Is there some particular bit that you would draw our attention to?
I would invite you to look in due course, not during the hearing. I think it's too long to go through. I
appreciate your setting us homework, Mr. Clark. I'm just trying to get a steer as to whether we need to read it all in view of the fact that the underlying circumstances are obviously completely different to what.
Well, I'm going to take you instead to the actual. In relation to the points I rely on, I'm going to take you to the paragraphs that the head note is summarising.
Okay.
First, if I just go to paragraph 17.
You mean of the judgment?
Of the judgment, yes.
Yeah.
594. Mr. Justice Fordham reviews 5 cases in relation to the discretion, including GE Eritrea. But for present purposes, the relevant cases are the 3 cases that he calls the in-need domestic cases, because these are cases where the principle about discretion is applied not in the context of an erroneous age assessment, but in the context of somebody accepted to be a child, but where there was an unlawful assessment that they didn't meet the section.
That's Lewisham, Enfield and Ealing.
So it's
1, 4 and 5.
Yes, that's right. And you see there, so for example, the Enfield case, this touches on the question of relief that I mentioned at the beginning. There was a declaration there requiring consideration of a discretionary power, and then in the AB and Ealing case, it was a quashing of a decision not to exercise the discretion. So it illustrates the types of relief that the courts can grant, and also the fact of the extension to cases not about age. But the key passages for present purposes are 23 and 24, the judge sets out a very detailed exposition of the principles that he, at 23, that he derives from the authorities, and then at 24, his own observations. And I would highlight 23 Roman 4, that the discretionary power to choose to treat the affected individual as a former relevant child is in the nature of a remedial power to remedy and for correcting the present injustice arising from past unlawfulness. And I say that's broad enough to cover the extension represented in the present case.
So you say what?
I say that given that the power is in the nature of correcting of injustice, that equally covers the injustice between former relevant child and qualifying young person.
Yes.
And then at 24 Roman 2, the judge simply makes the point that whether favourable exercise of the discretion is the sole justifiable outcome is an important question, but it can't exhaust the consideration that has to be given. I.e., where there's a question, even if it's not the sole justifiable outcome that the local authority should exercise the discretion, they have to give lawful consideration to the question of whether or not they should do so.
Right.
And then the final point, I think I've set out sufficiently for present purposes where I say that the injustice arises in the present case and why the judge, in fact, did have an issue to go on and consider. I just wanted to touch very briefly on Surrey's response to this ground. It's dealt with at paragraphs 83 to 87 of my learned friend's skeleton, which matches the response to cross-appeal, effectively incorporates it. Mm-hmm. It raises no dispute with the merits of the ground, the substance of the injustice and a need for consideration of discretion. The only points are BC didn't request consideration of the discretion. Surrey didn't make any decision not to exercise the discretion which could be challenged. And that the issue of whether Surrey should have treated him as a former relevant child rather than qualifying young person, quote, was not pleaded, not argued, and not dealt with in the judgment. Mm-hmm. In relation to the first, no request for an exercise of discretion, we saw from GE Eritrea that isn't fatal to relief in any event. And in relation to the second point, no decision to exercise discretion, assuming that BC had made a request, which I'll come to in a moment, the fact that it would be no answer to a claim on that basis for Surrey to say, well, we never made a discretion, we ignored your request. That would still be
Sorry,
unlawful.
I've lost the thread of that. Can you just go back
So the second point by my learned friend was Surrey didn't make any decision not to exercise the discretion.
Yeah.
And my answer is on that is, if there was a request to exercise the discretion, it's no answer to say, well, we ignored it.
Yeah, if a request was made,
yes,
then it should have been answered.
Should have been answered. So,
yeah.
And I say that in relation to all three of those objections, Surrey's position is just factually wrong, and the references for that are set out in BC's supplementary skeleton, paragraph 8.
Oh. So the letter of the 27th of April and the detailed statement of facts and grounds.
Yep.
Yeah.
So I think the documents that are referred to in the supplementary skeleton, the court has been taken to in the course of the hearing. There were three further documents I wanted to go to very quickly before finishing.
Those are all, I fully understand both the letter point and the facts and grounds. In fact, I think I made it plain yesterday in relation to another point that it was plainly within the statement of facts and grounds. What about the position in front of the judge?
In what respect, my lord?
Was it, what did it feature in the skeleton argument?
In the skeleton arguments, I'd have to.
Okay, all right. Well, don't worry about it now. I mean, in JR, lots and lots of points can get taken, but the judges tend to focus on those that were argued about. So it would be good to just to have the references.
Yes, my lord. I'm told paragraph 65 to paragraph 65 to 68 of the skeleton below.
So that's of the skeleton below.
Yes.
Thank you.
The three references I wanted to take you was in relation to the specific point that I understand my learned friend to be making, that there was no case on the gap between former relevant child and qualifying young person. There's in the supplementary bundle, page 159 is the final letter from Lawstock before the claim was issued on the 8th of July 22.
Want us to look at that?
Sorry?
Want us to look at that, or just
yes,
159?
159, my lord. And this is where the claim that in the alternative claim that BC would be a qualifying young person is raised and put to Surrey. And then
Which is the bit?
So claimant as a qualifying child is the heading.
Oh right, so it's the first headed paragraph.
Yes, and then the third paragraph under that heading says, without prejudice to BC's case that he is or should be treated as a former relevant child, then the defendant confirm it accepts that the claimant is a qualifying child, and if so, on what basis. So I say that says we're maintaining former relevant child, even if it's only the gap between qualifying young person and former relevant. And just as a note for your, a reference for your note, at 162 is Surrey's response refusing to accept that. And then the final thing I wanted to show you is paragraph 106 of the Statement of Facts and Ground. And that's at full bundle 364.
Say that again.
Core Bundle 364. This is the Statement of Facts and Grounds. And this is to show you how the discretion ground was put in those grounds. And the first paragraph begins, in the alternative to grounds 1 and 2, if it is held that the claimant was not looked after, brackets, either for 13 weeks or at all, and it's the words either for 13 weeks or at all that I'm relying on here, because if he was not looked after at all would mean if he were owed no duty at all, so the discretion would close the gap between former relevant child and nothing. And if he was not looked after for 13 weeks is if he was looked after for some shorter period, such that he's a qualifying young person. So it was within the scope of the grounds.
The paragraph 106 is a sufficiently clear exposition of your case.
Well, together with the fact that then ground 4 is qualifying child, and that's expressed to be without prejudice to the above, so the same point. They're still saying you should exercise discretion to treat as former relevant child. So in conclusion, I say that the discretion does apply to the kind of injustice that arises on the judge's findings. It should have been considered, and Surrey's response on this ground clearly fails because the matter was raised. Unless I can assist any further.
Just looking at the skeleton argument, you gave us the reference to paragraphs 65 to 68, which is page 192 of the core bundle. That's headed unlawful not to exercise discretion to treat BC as a care leaver.
Yes. That is, there's a paraphrasing for the purposes of that heading, certainly. But the details then of the submissions that are made would, so 68 is the application of the principles.
So anyway, it's 65 to 68.
Yeah, which then, I mean, they refer back to the submissions on earlier grounds, which are presumably the ones making out that the 13 weeks should have been.
Yeah. Okay.
So if we dismiss the appeal completely,
Yes.
we're against you on your first ground.
Yes.
But with you on this last round, what happens?
Surrey are required to consider whether to close the gap, use the discretion to close the gap.
Okay, so it doesn't ever go back to the judge, it just goes back to Surrey.
Yes.
Thank you.
Thank you very much. Mr Clark, anything else?
No, thank you.
Anything, Philippa?
No, thank you.
Thank you very much. Thank you very much, Mr Clark. Right, so the replies are, Miss Rowlands, you have the right to reply on anything that was said in answer to your appeal, plus any points you've got on their grounds 1 and 2, and then Miss Lou on ground 1 of the claimant's cross appeal, and Mr Clark on ground 2 of the claimant's cross appeal. That's right, isn't it? Those are the people who have a right to reply.
We might deal with it compendiously so that we don't take up too much time.
Well, that's fine. I think with a slightly holding your feet to the fire, I think we're going to be the time should be enough. So, Ms. Rowlands, which are you going to start with?
Well, I want to deal with a couple of points of details and answers to queries that have been raised. Then I want to go to my ground 3 and the cross appeal ground 1, which I see as two sides of the same coin.
Okay.
And then I will go on to the question of performance of the Section 20 duty, and go on then to discretion.
And so discretion, when you say discretion, you mean ground 2 of it?
Ground 2 of the cross appeal.
Okay.
A couple of points of detail.
So I've got 4 headings, which I shall keep you to. So heading 1, points of detail.
Yes. EHM stands for Early Help Module.
Thank you.
MAPE, M-A-P-E, stands for Multi-Agency Professional Enquiry. Multi-agency professionals involved they include people like the police, if relevant, education, people like that.
Are these module, are these Surrey's
Yes.
acronyms, or should I know them from other cases?
Different local authorities do use different
Different things,
acronyms,
that's fine.
and I think Surrey's are fairly idiosyncratic, actually. A lot of people refer to MASH for multi-agency safeguarding harm and
Yes,
things
yes.
like that. You might be more familiar with that.
Thank you, anyway.
Just to conclude on MAPEs, it was suggested that there was no MAPE in this case. In fact, if you go to page 18 of the supplementary bundle, and you will recall that there was a report from an anonymous person that BC's mother was not caring for her children properly. She said they were malicious. That did go to MAPE, and you see at page 18 the outcome of that. Thank you for the information you provided through MAPE. Based on concerns which were raised, further information gathered through MAPE and further discussion with mother, concerns raised have not been substantiated at this stage. information and advice has been given to the parents. Surrey Children's Service will not be taking any further action at this stage. That's the 2nd of September.
Yes, I'd underlined that sentence. Do we have anything further about the MAPE inquiry?
No, those would be somebody else's details, and they would be held by the police or whoever was involved in the MAPE, so not ones for Surrey to disclose.
So the multi-agency professional inquiry would be, as the name suggests, an inquiry to relevant agencies.
An inquiry into the anonymous complaint that had been made.
Yes, inquiry would go out to the agencies.
Yes.
And the information would come back to Surrey. I'm just guessing now.
There probably would have been a meeting. In 2019, it might well have been a physical meeting, because that's before the pandemic. And people would have exchanged views and information.
Would it not have been minuted?
Yes, but not by Surrey.
By who?
Probably the police.
Without a record, I'm sorry to cross-examine you, without a record being given to held by Surrey?
Surrey would have been present at the meeting, and you've got the feedback there in the records. That is sufficient for these purposes.
But how is the decision maker going to make a decision on the statutory obligations Surrey are under, without having the information before them in specific?
Surrey Children's Services, having been part of the MAPE inquiry, reached the conclusion at that stage that they wouldn't be taking any further action on the substance of the complaint made by the anonymous person.
That's the August bank holiday anonymous complaint.
I haven't checked the date of the bank holiday, but yes.
Well, it was. I think the judge found that it was over the bank holiday. It was the end of August, and we've seen Miss Lou showed us the other documents relating to that. Yeah. Okay.
So that was one point. Another little point was simply about private fostering. You've just heard reference to that, and it was pleaded, but because BC was at all stage over 16, private fostering could not arise. Yep. Section 66(1) of the Act. I think that was all I wanted to say in relation to points of detail.
Okay.
Oh, there was one more. VSMO. MO stands for Management Oversight, and the VS would have been the person who took the call and carried out an initial triage and said this ticks the boxes to be passed on in this way. So that's what that means in that record.
Because it's PS-MO before I can't remember the page now, but it looked like that was a message sent from PS to MO, but you say MO is management oversight. So PS could be somebody, but...
Oh, she was a VS.
It was a VS, yeah.
Pardon?
It was VS, not PS. VS.
VS.
Yeah. Somebody whose name began with a V.
Thank you very much.
Do you mind if I go back to the earlier note, Peter?
Pardon?
Let's just ask a bit more about this note. Do you mind?
No, please, by all means.
I'm sorry to scratch away at something which may not be helpful, but can we go back to the note on page 18?
Yes.
I'm just puzzled as to who wrote it and what it's... So who wrote this note? It looks as though it was written by VB.
Yes, indeed.
Addressed to... who? Doesn't matter. It's a... VB is the children's single point access at MAP.
Yes.
In a case which there's been some criticism of cutting and pasting, has that been cut and pasted? Is that an email that's been cut and pasted and stuck here? Sorry, that sounds...
Yes.
Yeah, I mean, we don't know how digitalised systems work. So VB is the map contact, and that looks like an email which was sent to somebody else, and then copied and pasted. But I'm speculating.
So
Despite the good morning, it doesn't look as if it's sent to anybody.
My speculation, and this is, we mustn't, I wondered whether it was an email sent to lots of people and then cut and paste and put in the file.
No, I see.
that's certainly on Surrey's case file. It's arising out of the accumulation of the complaint, the telephone call made to mother and indeed to father, who were willing to have the referral made. I am recommending for a MAPE to be considered at this stage. It says at 16, and then at 18, that's where we say MAPE has happened and NFA. No further action.
I know.
You just looked at
You
me.
may think I'm ignorant about, there are some acronyms I've come across before. Yes. I mean, okay, I'll be repeating myself if I said it.
I mean, this is in the context of, as we've seen, a family who's got low-level problems, and there's been low-level intervention over a bit here and a bit there. It's not been a family that's needed a huge amount of social work intervention. Then you've got this complaint that says the children are neglected, has to be investigated, it has to be looked into. It's looked into, there's no role for children's services, and that's the decision at that stage. And that's not subject to any challenge, obviously.
And your point is that we shouldn't worry about that when considering the rationality of the local authority's actions.
I would certainly accept
the
that
judge's assessment of the rationality.
it forms part of the factual matrix, but it doesn't dictate any decision one way or another.
Thank you.
So then we go to your reply on ground 3 and your response to the cross appeal ground 1, which you say are two sides of the same coin.
And the reason why I say that is because whether Section 20 applied in this case, it's a two-part inquiry. One is, did the duty arise? And two is whether there was performance of it. If there was no performance, then he doesn't qualify as one of the categories. And I should say I prepared a note of the various categories. My learned friend wants to have a look at it more deeply before I pass it up to you. Eligible, relevant, former relevant or qualifying. And if he doesn't actually get accommodated, he doesn't come into any of those categories, and the question of discretion then arises. So the question of performance is important to my ground 3 and to her ground 1. Her criticism in relation to my ground 3 started off by saying the judge did not find what I say he found. That is to say that there was immediate Section 20 duty from the moment he first presented, because she said he didn't find that it arose until the 18th of September. In fact, if you look at paragraph 31 of his judgment, I'm having technical difficulties with the machine at the moment, I'm afraid. So if you'll just bear with me while I do some scrolling.
Paper is best.
Yes, but it weighs a lot.
Well, I understand.
The one bit of advice I always give, got many people with me, the one bit of advice I always give is look after your back. And being able to carry things around has made, on electronic versions, has made my life so much better. My back so less.
So paragraph 31.
31 is at page 138 in the bundle.
Where he rejects your submission.
Yeah. Snap judgment, unable to make, and instead entitled to take time to determine what inquiries were necessary to enable it to decide what action to take before deciding whether BC was a child in need of accommodation. He says, well known to SCC with his history of children's services involvement. I say a very low level involvement, never requiring, of course, accommodation. It was clearly the case, he says, that in accordance with paragraph 3.4 of the guidance, suitable emergency accommodation for BC was required whilst his full needs were further assessed. Despite this, SCC inexplicably failed to provide BC with any accommodation and indeed failed to take any steps to assess his case at all until 18th of September, being 5 days later. So he is saying 13th of September, there and then, we have to provide him with accommodation. And that is because he is looking at 3.4 of the guidance, which talks about people who are street homeless. So from that, I take it that the judge is saying that the local authority is not entitled to stop and think, to actually ask the question, to carry out the evaluation necessary for the evaluative judgment, and must immediately just provide accommodation for somebody regardless of whether or not it pans out that in the evaluation that they carry out, he needed accommodation.
Which part of your submission is he rejecting? It looks as though, on reflection, he may be rejecting the second part. He may be saying that he rejects your submission, that you were entitled to take time. Is that right?
Well, he's saying that just the mere fact that he's applied to Runnymede as homeless, and Surrey have been told about that, means that we must accommodate him.
On a sort of interim relief basis.
Yes.
They think about it a bit more, but he's more or less saying that, isn't he?
And you had enough, he says that you had enough, because of the history, you knew enough to make the decision without.
Well, we've just been looking at the last bit of information about him. Children's Services didn't need to intervene on the 1st of September. 13th of September, we get the information that he's applied as homeless. Not that he has been found to be homeless. Now, homeless in this case is doing a lot of work. So we've got homeless in the sense that he's applied to Runnymede for assistance under Part 7 of the Housing Act 1996, which gives you the definition of homeless under Section 175. But even under Section 175, the word homeless can have a wide range of meanings, because you can be someone who's rough sleeping, has absolutely nowhere to go. You can be someone who is sofa surfing, doesn't know where you're going to be kipping tonight. Technically homeless, like, for example, the girl who was allowed to stay in her mother's flat until she turned 18, her tolerance, the landlord tolerated her there. Or someone who was accommodation in the sense of bricks and mortar, but it is not accommodation which is reasonable for them to continue to occupy, because it's overcrowded, because it's in disrepair, because it's unaffordable. And they could present to the local authority, the local housing authority, who could then say, yes, we accept that you are homeless, even if you can remain where you are for a period of time until it takes the local authority 3 months, 6 months, or however long it is, to arrange alternative accommodation. If you turn up at the local housing authority's door with your suitcase in one hand and your 3-year-old in the other hand, and you've got no roof to go to, the local authority must then provide you with accommodation. You then will have temporary accommodation. You've got accommodation, you don't require accommodation that night, but you are still homeless within the Section 175 definition. And so that's what we were looking at in the Essex case in relation to the difference between being homeless under the Housing Act and requiring accommodation under Section 20. So the relevance of that is that just being homeless within the meaning of Section 175 doesn't mean to say that the local authority must then jump in and provide emergency accommodation. They're entitled to look at whether or not, in this case, BC could go and stay with Kane that night, because that was accommodation that he already had available to him. It was accommodation of his choice, and it was accommodation that he said he was happy in and wanted to go back to. And that comes down to a finding of fact by the local authority, which is part of their evaluative judgment. And as was noted in TW and Essex, is a forward-looking decision as well as a there and then decision, because Section 1710 exhorts you to look at the future, and it is a question of whether it appears to the local authority that you require accommodation under Section 20. And it doesn't have to be perfect accommodation. It doesn't even have to be suitable accommodation within the Housing Act meaning, because that is part of the Housing Act as well as Section 21. The only way the word suitable comes into Section 20 is in Section 21C, where you're talking about parents being prevented from providing suitable accommodation and care for the young person. It doesn't say that the local authority has to provide suitable accommodation, but it's generally seen as being sort of inherent in that act, that what the local authority will do under Section 20 is provide suitable accommodation. It wouldn't be a reasonable response for the local authority to provide anything other than suitable accommodation. If you are locked out of your perfectly nice 3-bedroom house because you've lost your keys, you can't get access to it, you're not homeless, you do have accommodation available to you. So if you have got accommodation that you simply can't access for a brief snapshot of time, you're neither homeless under the Housing Act, nor are you requiring accommodation under Section 20. And the local authority properly takes a longitudinal view of this. So the duty does not arise just because you are told that person has applied as homeless. It seems to me that what the judge below was doing was applying a false dichotomy of saying you're either living with your parents or you're accommodated under Section 20, and there's no other between options. In this case, there were other between options, and particularly, in fact, the accommodation with Kay and his mother, and that was a perfectly normal family arrangement. It is sometimes said that there is something called Section 20 accommodation, a children home, but Section 20 accommodation can be whatever suits the person in question. Coming back to my opening submissions about everything being person specific, and you don't have a tick box approach to a 17-year-old needs this or a 16-year-old needs that. It's what does this person need? And this person was someone who was happy to live with Kay and his parents, and it was someone who was looking to pay his way, for example, quite laudably, and so he was someone who was taking a responsible approach, it might be said, to that aspect of things. So
But that submission holds good whether the duty arose on the 13th of September or the 18th of September.
it does,
Or sorry, the asserted duty.
yes.
I mean Miss Lou made the fair point that she can only meet the points that you're making in your grounds of appeal, and there is still this point that ground 3 says immediately, and I understand that goes to the 13th of September point, but actually most of your submissions are apply whether it's the 13th of September or, as we see later in the judgment, the 18th of September.
It does, but
I appreciate there may be a performance point, and because time matters, I understand that. But just on the question of whether there's a duty, is there any particular relevance of it being the judge, you say, finding the 13th, not the 18th?
it's the fact that he says it arises without the local authority having the chance to make its own decision, which then leads into the other grounds that I advance about.
Okay, but the local authority did make a decision, because
On the 20th.
we agreed with that on the 20th. So assume you're right about having time to make a decision. By the 20th, they had made a decision.
Yeah.
So it doesn't seem to me to be, ultimately, it doesn't seem to me necessarily to matter very much.
I would agree with that in that I say that the judge got it wrong on both grounds.
Yeah, okay.
And didn't really look at the fact that the local authority had made a finding of fact that BC had accommodation available to him. He rejected my submission, you see at paragraph 69 in the judgment at page 148, that the fact that the offer to bring the grandparents' caravan to the site or the arrangement with Kay's mother meant that he did not reasonably appear to SCC to require accommodation.
Sorry, forgive me, I've lost track of the paragraph number.
69.
Thank you. Yeah.
So he says that the caravan was obviously not suitable accommodation. I find it hard to see why he says obviously. I think it must be based on his previous reference to BC's subsequent witness statement, which was obviously not what was before the local authority at the time of the decision, so it wouldn't have been obvious to the local authority that he said it was dilapidated and so on. SCC could not reasonably have concluded it was 18th September, and SCC didn't even bother to inspect it. But why would the local authority inspect caravan when BC said that he wasn't going to live there, and when he had alternative accommodation available to him? His primary accommodation was with Kay and his mother. Then he goes on to say the suggestion that the accommodation offered by Kay's mother was suitable for BC is unsustainable by reason of its nature and precarious duration. But there's nothing in section 20 that requires accommodation to be tenancy or any kind of security of tenure. He was able to stay there as things turned out over a period of time. Just on this point, very briefly, you've been taken to, in the medical records, the reference to him having been kicked out on the 16th of October. The only reference to that we have 92, I think it was. So yes, at page 92, the note in there, 17th of October at 20 past midnight, brought in due to suicidal ideation, recently kicked out from friend's place where he was staying and started expressing suicidal ideation. Prior to being brought in, he reports to have drunk.
SB 92.
Yes.
That's the kicked out from friend's place point.
That's right. That's the only reference to him ever saying that he'd been kicked out. As at that point in time, he was so drunk that he was not fit to be assessed, and he was not able to remember anything about what was happening the next morning. But what he did say to Jane Stubbs, which we see at page 53 of the supplementary bundle, so she gets the call on the 17th of October. We see second entry down on that page. Hi Jane,
Page
53. Hi Jane, do you work for the Targeted Youth Support Team? If so, could you please give me a call? That's from the AM, who we've seen the records from. Meeting with Brandon in the section 136 suite at Farnham Road Hospital. He was not happy. He was in the suite, demanded to be let out. BC could not remember much about being admitted, was unaware of where he was. I explained what had been told and asked how he felt. said he did not feel suicidal and just wanted to return to, and that's to Kay's house. And over the previous page, 52, Miss Stubbs then calls mother, and she says yes, she'd heard that he'd been sectioned last night. He's now being discharged, returned into Kay's mum's home, where he's currently staying. And I explained that Kay's mother is happy to accommodate Brandon, but was then inquiring if Brandon's family could provide some financial support.
Mm-hmm.
So
the only reference, the only evidence that he was kicked out, quotes, is something is reported as having said when intoxicated.
yes.
And then there was an implication or inference which Miss Lou drew from another note about something that Kay's mother had said, wasn't there?
Not sure which one you mean.
The top of page 53, the same page.
Yeah, that's right.
With Kay's mum.
That's right. It's because it's the very first line on 53.
Yeah, that's right.
She
agreed. She would still
unaware
let him
he'd been
remain.
sectioned and believed he was staying at his sister's.
So certainly, by the very next day, by the 17th of October, there's no suggestion that he's being excluded from Kay's mother's, where he's been living since. Well, we don't know exactly when he's been living there, but certainly sort of September at least. And we also know that that remained the case for the next period of time. By, for example, page 30, 1st of October, she goes to visit him and records.
So page
30 of the supplementary bundle. In the middle of the page, 1st of October. He's currently living with another young person who's known to our service. This boy's parents are happy for BC to carry on living.
But this is back in time.
For the foreseeable future.
We've just been looking at the 17th of October and the message is there. This is 2.5 weeks earlier.
So it started off in September.
I mean, there's
In
no
October,
dispute.
it
There's
seemed-
no dispute that he was at Kay's mother's at some point before he was hospitalised. So I don't see what this is a point of reply to, and I don't see why we're going to having looked at the stuff on the 17th.
Well, we then simply, all I'm saying really is that there's a longitudinal picture of someone living there on a regular basis. So my overarching submission is that the judge has placed far too much weight on the fact that he applied as homeless to Runnymede. He wasn't someone who required accommodation as a result of that. He wanted accommodation from Runnymede, and recall, of course, that the first letter before action was directed to Runnymede because he wanted to be accommodated by them. So the other point about the longitudinal view is that it would be overly intrusive for the local authority to be checking on a daily basis. If you want to know whether somebody is in need, you need to look at it on a relatively relaxed basis rather than every single day. Where are you going to be sleeping tonight? Where are you going to be sleeping tonight? Where are you going to be sleeping tonight? That is something that the local authority doesn't do. The local authority's job in these circumstances is to support the family to stay together, to support the person to stay in the family home, and if that cannot be done, to support them moving forwards to independence. And it is in that context that we look at the text that was sent to him about the outcome on the 20th of September, and that was on page 26 of the supplementary bundle.
Yeah.
So he knows that he's had a conversation with the social worker Vanessa. He knows that he's applied as homeless to Runnymede. He knows that his mum's been spoken to, and at this point he is told, hi Brendan, I'm going to ask someone to support you with college, so someone will be in touch, but I can't say when. So he knows from that he's not going to be taken into care, given accommodation under Section 8. It is supporting him to remain where he was, staying with Kay and his mum, supporting and valuing the wishes of the child in the case. So the reason why I say that this is the flip side of my Learned Friends ground one is that it's all about when the duty arose and how it was performed. Because her submission was that by supporting BC to remain with Kay where he already was, that was performance of the Section 20 duty. So her contention is that Section 20 duty had already arisen by then. They should have found by the 18th of September the Section 20 duty had arisen. And what they were doing by saying, yeah, that's fine, stay there, is performing the Section 20 duty. My lords, my submission on this is simple. Respecting the status quo is not performing a Section 20 duty. First of all, because Surrey clearly had made a decision that they did not consider that the Section 20 duty had arisen, because they didn't consider that he required accommodation. But certainly they thought that his wishes to remain with his friend were wishes that a 17 going on 18-year-old child was perfectly entitled to have and to fulfil. They had checked over the situation, talked to both sets of parents, made sure that the accommodation was available, and that was it. They were doing no more than oversight rather than arranging accommodation. So for that reason, my lords, my lady, I say that ground one on the cross appeal must fail. Even if the Section 20 duty had arisen, Surrey didn't do anything in performance of it, neither on the basis that is advanced by my learned friend or on the basis that was found by the learned judge. What the judge found was that when Jane Stubbs, first of all, took BC back to Kay's house where he said he wanted to go, and then put the two mothers in touch with each other afterwards, that amounted to arranging the accommodation. That was not open to the judge to find on the facts. There must be a significant role played by the local authority in the arrangement of accommodation. I mentioned earlier that the judge used the wording that relates to the private fostering kind of cases, and this cannot be a private fostering kind of case. But you've been taken today to read B, which is at tab 25, page 541 in volume 2, and you will see in that case the language of private fostering arises in there and is cited by the judge. At paragraph 65 and 67, you've got the kind of issues that arise in this kind of case. And at 65, on page 555, it was found that the claimant in that case was seeking to build bricks without straw, in submitting that when the local authority was unable to find a foster carer for Jay, the father had in some way made a private family arrangement by virtue of having rung up DB to see if he might be willing to take Jay with him. And at the bottom, I fully accept on the face of it the absence of any other formalities would seem to point away from the placement with DB being a section 21 accommodation.
Sorry, this is page?
Page 555 in the Bundle of Authorities, Volume 2. It is all about the facts on any individual case. Even where there was some formality and some placement work being done by the local authority in that case, that was described as building bricks without straw. But in my submission, this is even fewer straws to build bricks from. The bricks were already there. There was a fairly solid arrangement between BC and Kay and his mother that they had reached themselves, and it was not anything to do with Surrey. So that's grounds 3, grounds 1 being flip sides of each other. The findings of fact by the local authority were that he was not homeless, didn't require accommodation.
On ground 1 of the respondent's cross appeal, I understand the case that says there's no section 20 duty. You submitted a few minutes ago, even if a section 20 duty had arisen, Surrey didn't do anything in performance of it.
Yes.
That sounds a slightly odd defence, if you see what I mean. If there was a duty, and the question presupposes that there was a duty, but if there was a duty, how is it that not doing anything in performance of the duty avoids a liability?
Because Hammersmith in Fulham, G. Eritrea tell us that if we didn't do anything, you can't deem it to have been done. So there has to be duty plus performance before you get into one of the categories of eligible, relevant, former relevant or qualifying. If there was...
What was the Eritrea, what was the other one?
Hammersmith and Fulham.
Oh, yeah.
If a duty had arisen and Surrey didn't perform it, then we go to round 2 of the cross appeal, which is the exercise of discretion.
Yeah.
But if we didn't perform it, then he did not qualify as a relevant, former relevant qualifying child.
So I've got your third heading as performance.
I think I've run into performance rather than respecting the headings. Can I substitute?
You've dealt with... right. So you've dealt with performance under what was your second head, ground 3 and cross appeal ground 1.
Yes.
Which is not unreasonable since ground 1 of the cross appeal is concerned with the performance. And you're replacing that with?
Delay. I forgot to mention. I should come back on that one.
Delay. All right. Well, so are we moving to that now? Or are we moving to ground 2?
Can I go to ground 2 because that flags up the question of delay?
Okay.
I do find that all these issues are interlinked to an extent that stops me really dealing with things in the headings that are so dear to your lordship's
Up to a point they are interlinked. I accept that, but up to a point they're not. It'll be a question for us as to where one does legitimately roll into another and where it doesn't. So ground 2 of the cross appeal.
And I do accept that if the section 20 duty had arisen and Surrey had failed to recognise that, Surrey would have a discretion to consider whether to remedy the injustice done in the circumstances. That is not the dispute between us. The dispute between us is, first of all, we do not say that the discretion arises on the facts because no Section 20 duty.
Sorry, say that again. That's not the dispute because...
On the facts, no Section 20 duty ever did arise. So there's no discretion, there's no...
Yeah, okay, understand that.
Nothing to remedy.
What if we were against you on that, so that a section duty did arise,
Yep.
you didn't perform it, you say, well, that you can't deem it, so that's that. Do you accept that the discretion would arise there?
At that stage, yes. However, not in the way that it's been pleaded in the case before the judge below.
Hang on. So if duty and no performance, discretion may arise, and you say yes, but not in the way it's been presented.
Yes.
Because?
Because, first of all, we looked at the letter before action. The correspondence started off with a complaint that the local authority had not exercised its discretion in this case. At that point, nobody had even asked the local authority to exercise their discretion. So the letter before action went in with a complaint that was completely unfounded, and then that was carried through to the way that it was put in the claimant's grounds. And those are in the core bundle starting at 329. And you've got ground 3, which starts at page 364, paragraph 106.
Yeah.
In the alternative to grounds 1 and 2, if it is held that the claimant was not looked after, with the result that he is not a former relevant child as a matter of law, then the claimant's case is that the defendant should exercise its discretion to treat him as a former child, and its refusal to do so is unlawful. So the claimant asserted a refusal to treat him as a former relevant child. The refusal identified by the claimant is the letter of the 12th of May 2022. That's at page 148 of the supplementary bundle.
148.
148.
Yeah. The last, I think, in the chain of pre-action correspondence.
Very close.
Nearly last,
Very
not
much.
quite. Yeah.
And 12th of May 2022, you will not see in that letter a refusal to exercise the discretion.
Right.
Really, because nobody considered that the discretion arises. My learned friend says, well, you don't need to be asked to exercise your discretion. G.E. Eritrea says that. And you do need to have an appreciation that the facts giving rise to a discretion arise. And what Surrey have said throughout is that we do not accept that there is any discretionary scenario here, that this is not a case where there has been any harm done to, or any wrong done to BC, because the Section 22 duty did not arise. He had accommodation, he didn't require accommodation, he wasn't a child in need. However, if a discretion had arisen, Surrey would not have decided to exercise it. And we can see that from the statement of Miss Andrews page 178 in the supplementary bundle. And she said,
Page? Did you say?
178, paragraph 22 onwards. She deals with the questions of what happened in October. Even at that point, he didn't seem to be within the Section 20 criteria.
Sorry, which paragraph do you want to look at?
So starting at 22, going up
Sorry.
through 25,
Thank you.
30 onwards. Paragraph 35, the letter from Lawstop to Runnymede Council was copied to Surrey. It came out of the blue. They complained that we'd failed to consider the exercise of the discretion. Of course, when he turned 18, SCC were not currently involved in his case and therefore had no reason to consider exercising its discretion. It was not until the 9th of September 2021 that Lawstop actually requested that SCC exercise their discretion and pointed out that there was no reason to consider that BC was homeless or that there was any reason to consider that he was in need of assistance from Children's Services in the 13 weeks before he turned 18. There was no reason to consider that SCC should exercise discretion in this case. I do not consider that not doing so causes him any injustice. This is because of the facts which show there was no duty at the time, so there's no injustice to remedy, and also because he has had support and housing available to him in this time. He's not lost out on any services. It's further because of the long delay in coming forward to seek the exercise of this discretion. He is now nearly 22 years old, now over 24 years old, of course, and not in education or training. So by the time the court considers his case, he will be past the age at which any residual leaving care services could be considered in any event. I do not consider that there's anything that shows that BC had or has any unmet needs that Children's Services should have met in 2019 or should be meeting now. So even if there had been a discretion, Surrey would have decided not to exercise it for those reasons.
Can you give an advance view like that? I thought there was a basic principle of public law that you couldn't fetter the exercise of your discretion.
It's not
so that if it were to be our conclusion, if we got to that point, if you follow down through the flow chart, we got to the point that we thought there was a Section 20 duty that hadn't been exercised, and so the issue of discretion arose. Wouldn't that now go back to your clients to say, are you going to exercise it now? Because that's what we think ought to happen.
They would take into consideration all the things that are set out there, the lack of any detriment to him, the delay in coming forward, the fact that he hasn't lost out on anything as a result. He's had housing, he's had support.
There's maybe material elements that they would put into their evaluative decision, it's not even evaluative, it's their discretionary exercise.
Discretionary exercise.
But isn't really what you're saying is that it's, as things stand, there's no basis for you to exercise discretion, and it would only arise, I suppose, if we came out in a particular way in this judgment.
Because there is the claim in relation to the failure to exercise the discretion, then it's not really proleptic, it is looking at the discretion.
Okay, so it was claimed, it was answered.
And the reason why I say that this circles back to the question of delay is for two reasons. One is that the letter of the 12th of May 2022 was relied upon as a decision, and the judge was...
letter of which, sorry?
The letter of the 12th of May 2022, page 148. The judge was persuaded that that was therefore a relevant factor in relation to delay, because he thought that that was one that triggered a right of judicial review, even though there isn't any decision in that letter at all.
Where's that?
So he says that at page
148, you said.
Yes, in paragraph 102 at page 158.
Oh, are you in the judgment?
In the judgment, yes.
Sorry, my mistake.
Yes. Surrey's refusal dated 12th of May 2022 was challenged in time. Well, it
Yes.
wasn't a refusal, and
Well, it depends on what it's a refusal of.
well, it doesn't refuse. It doesn't refuse as discretion, which is what it was relied upon.
No, I mean, yeah, okay, well, it'll be for us to look at that.
In relation to delay, just a couple more short points. My lady yesterday asked me to consider whether I agreed with paragraph 21.8 of Thornton Hall.
Yeah,
And that is at tab 22449. The court will not interfere with the first instance judge's decision unless it's flawed by a misdirection of law or by a failure to have regard to relevant considerations or the taking into account of considerations that are irrelevant or the judge's conclusion is clearly wrong. I do agree with that. And I say that in this case, what the judge was not doing was exercising a discretion. He made an error of law because he found that there was an ongoing breach. And I think
It
what
just
you
felt
heard,
like if everybody could agree on that, we could save quite a lot of time writing it up, really. If that's the agreed test, that might help a bit.
it seems to me that I cannot disagree with a word of that. It may be difficult to separate the exercise of discretion on remedy from the considerations bearing on the discretion to extend time, and care must be taken to distinguish in those cases. I would agree also with that. There was a point to be taken about the judge fails to look at my point on delay and remedy as well. He didn't make any findings on that. And I do say that this was not an ongoing breach.
well, that's a separate point. On the question of it going to remedies, your point was it was out of time under 54.5.
Yes.
In a case like this, delay may be relevant to remedies if, for example, there was a claim for financial loss going back over the period of the delay. But as we know here, there wasn't. So at the moment, on the facts of this case, I can't see that there's a separation that you could be wrong on the 54.5 point, but then delay would then be relevant to remedies.
I think I did manage to find an argument before the judge, but I'm struggling to remember it now, I must admit.
That's the thing about administrative law. Nobody ever makes any concessions because everybody thinks, well, there may be something in it. But actually, on the facts of the individual case, whatever the general proposition is, I can't at the moment see that delay in relation to remedies is relevant in this case. I can see delay is relevant, and by all means make any submissions you want on the continuing duty point, because that's obviously important, but that's to do with the 54.5 point.
Well, my learned friend referred to this being an accrued right. An accrued right is not the same as an ongoing breach, where the local authority is doing something wrong now. In all the cases she referred to before the learned judge, there was this child who could still have another bite at the cherry, who could come back and say, I am still a child in need. This is a case where the door has closed There were events in September and October 2019. We've examined those in detail now. That was what happened. That's what his complaint is. That was a complete set of events, and that is not an ongoing state of affairs where there is an ongoing breach. That is a failure to act then, if he's right on that, which of course I say he's not, which has ongoing effects on his entitlements. It's accrued rights, as I say, rather than being an ongoing breach. There's always going to be an ongoing state of affairs in any case of judicial review, because otherwise why would you want to seek judicial review if there wasn't something that you wanted to change? And so that does not of itself give a right to seek judicial review out of time. What I would invite you to do is to look at the application to extend time, which is in the core bundle at page 227. Because at first, when the claim was lodged, there was no application to extend time. It was only in August 2023 that there was an application for an extension of time. I don't know if I said 277 or 227, it is 227. And his position...
227.
227 of the core bundle.
Right, because 327 is the claim. The judicial
226
claim.
is the start of the application notice.
And then 227 is the extension application.
That's right.
Yeah.
The claimant's position is that his claim was brought within time. Defendant's failure to accept that the claimant is a former relevant child is a continuing breach, as it was and is an ongoing state of affairs until at least the claimant's 25th birthday, while its refusal to exercise its discretion to treat him as such was a decision dated the 12th of May, the claim was issued on the 10th of August and is therefore in time. On reflection and out of an abundance of caution, a protective application is being made for an extension of time. Could not have brought the claim earlier, and there was a good reason for any delay. The claimant was unaware of the possibility of bringing a claim until he instructed solicitors in July 2021. Does prompt you to wonder why he instructed solicitors in that case, and then engaged with correspondence with the defendant via solicitors, but it was not possible to bring a claim at that time because the defendant's resistance to disclosure of the social services file. Well, there was no resistance. Simply said, make a subject access request and we will deal with it. But it wasn't until October that it made the subject access request. And this is a fairly normal way of proceeding in these cases. So it was, I've already gone through the dates of the pre-action correspondence. The response to that at 202, 203
to
in fact, let's go back to 199. This is my response. I make the point clear that the events upon which the claimant relies took place in the period September 2019, which should have been brought by the end of 2019, has not been brought promptly. This is not a case where permission should be granted in order to ensure there's an effective remedy for maladministration. The time in which the claimant could have benefited from services as a former looked after child has expired. I made the point below that there's the fully established claim for bringing the grounds, and
so that anyway, that's your response, and you go over the cases.
Yeah. And so at paragraph 13, claimant contends no prejudice to Surrey arises from his delay. This is an intensely fact-sensitive inquiry. The defendant was not able to inquire into the claimant's case until a significant period of time. Memories faded, personnel moved on. Some records are unavailable due to a change in the recording system. My learned friend says there's no evidence of that. Miss Andrews, in paragraph 4 and paragraph 12 of her statement, does give that evidence. We also say, paragraph 15, lack of benefit to the claimant. And this goes back to the fact that he was already 21 by the time the claim was brought. And as I make the point right at the outset of, well, every document I've submitted to the court, because he's over 21, he's really got no benefit to be got out of that. If he had been in ongoing education...
Was he over 21?
Sorry?
Was he over 21?
He was over
He was
20...
born on Christmas Day 2001. So when the claim was started in August 2022, he was 20.
Nearly 21.
Fine, I understand that. But at the time that you said at the time the claim was started, I was just picking up on that. He was 20 when the claim began.
August 2022. He was very nearly 21. By the time we got to court, certainly he was over 21. Had he been in education, employment or training, there could have been the extended options for treating him as a qualifying child in education.
But these don't go to breach, do they? Your point is...
This goes to delay and discretion and points that the judge failed to consider. The prejudice to Surrey versus the benefit to...
But it's not... Your point is, thinking of my Lord's analogy with nuisance yesterday, the period, the period of breach was what up to his attaining the age of his majority, or 18. And you're saying that what happened thereafter are such rights as he may have accrued in that period.
I don't agree that the period of breach was until he reached 18.
Or whatever, at the latest.
Because the question for judicial review is, when did the grounds for bringing a claim accrue? And that was September the 20th to start off with, possibly October afterwards.
Okay. I'm being imprecise, but this was not an... This was... You say this wasn't an ongoing breach.
Yes.
It had come... The breach had... If there was a breach, it had happened. Yes, there were rights which were accruing, if it's right that there was a breach. But the fact that there were rights that were still accruing...
Yes.
Did not mean that there was an ongoing duty or an ongoing breach for purposes of considering delay.
That's right. And of course, the word promptly has to be part of any discussion of delay and fails to appear in the judge's judgment other than when he records my submission that he should be considering it. So yes, when you're considering delay, what I was coming back to, paragraph 61 of the judgment. I do not accept the submission of Surrey that no purpose would be served now in granting the relief sought by this claim, and that there's no apparent lacuna in the claimant's life that Surrey would be required to fill. I made the point that he got support, he had accommodation, he said he still wanted to go back to college, but in fact, because he'd left college, he no longer, at 21, was entitled to be treated as an ongoing qualifying child. And so he does not factor that in to his consideration of delay, benefit versus burden. Burden on Surrey for having to deal with a claim that came out of the blue, to use Miss Andrews' words, where records had been lost, memories faded, against no real benefit to BC coming out of it. And at the to deal with it at the end of his judgment as well, I did submit to him that he should be dealing with it at the first part of the judgment. That's my skeleton, paragraph 16 on page 204 of the core bundle.
Well, on that, I don't think anything turns on that. But I mean, I understand that submission as a matter of generality, and usually in these cases you do deal with delay up front, and there are some aspects of delay here which might have been better if they had been dealt with up front. But for example, the continuing duty point on which the judge places quite a heavy reliance, it might be said, well, actually, that could only really be bottomed out once he'd dealt with the substantive issues.
I see that as an argument. I think it's wrong because you did have a discrete set of dates that were particularly relevant to this question. And if there was no performance by Surrey of that duty, all that there could be would be a discretion, and you had an identified date for that. But wrongly identified in my submission, of course. But
Leaving aside that, does anything turn on the fact that it was dealt with at the end rather than the beginning?
It just suggests that the judge was making that decision because he'd reached the decision that BC had a good claim rather than the other way around.
You've got better submissions.
Even if there was an ongoing breach, my final point, I think, that does not absolve you from the duty to act expeditiously once aware, and it is clear from all the correspondence that he was aware of the right to bring a claim right from the outset because the solicitors said as much. If that was not true, they shouldn't have said it. If it was true, they should have issued.
Can I ask you something about that at this point? You'll be more experienced than I am on judicial review matters. This must happen quite a lot, that a claim is known in outline, but the details of the claim may not be known until there is disclosure. What do the guidance and protocol, judicial review protocols say about how you should approach that situation if you're in a claimant's position?
Well, as my learned friends both said, I think, there is the pre-action protocol.
Yeah.
You're supposed to give full and frank disclosure up front. So there's a duty of candour in judicial review cases rather than a duty to make disclosure in the way that you do in a normal civil claim. You can always amend. If something comes out of the woodwork after you've issued your claim, once you've got in, you're in. And you can amend your grounds of claim. You can.
Is there an opportunity for disclosure to be sought and given after issue but before permission? I ask from a position of ignorance.
Yes.
Is that it? Right. Do you have any submissions about that in this case?
I'd have to go back over the papers and see what was actually said at that stage, but I don't think I do, no.
You could have, I mean, in some cases where you think there is going to be a tangle on the documents, I mean, you do sometimes see it, and different judges take different views on it, but you can ask for the permission decision not to be made until you've resolved the documents issue. I mean, it's a flexible rule book.
It is. And there's one case that Miss Lou and I are involved in, where she actually submitted her grounds, I think, in February last year, and we're still waiting for permission. And in that time, she's amended her grounds twice. I've amended my response, and we've had such a change of factual scenarios over the time. Her client, you don't need to know the details, but things, we have this kind of rolling judicial review going on. So things can change.
I mean, when judicial review is not meant to be a rolling process, but there are just cases, I can think of some that I've been involved with, where you need to know a bit more before you can really put your stake in the ground.
But sometimes
what you can't do is sit on your hands and not issue.
What you can't do is sit on your hands for 10.5 weeks. Once you've said, this is it, I'm going to issue now. 10.5 weeks later, you finally issue. And still say that you've been prompt. That's what Law Stop did in this case.
Anything else by way of response, I suppose, or to grounds 1 and 2 of the cross appeal?
Bear with me while I just check through my notes. I think that is everything I wanted to say. Anything further? Unless there's anything further I can assist your lordship, dear lady, with.
No, thank you very much, Mr. Rowlands. Now, Miss Lou, are you?
I'm going to be extremely concise.
Yeah. Are you dealing with both grounds?
No,
or?
I'm going to deal with ground one.
Fine. Okay.
Because Mr. Clark is the expert on ground two, and I won't steal his thunder.
You'll be able to say to people, I was in front of Lord Justice Coulson, who's obsessed with headings. It's just. I find that unless I have the headings.
Coulson on headings.
Yeah, exactly.
I could see the book coming.
I occasionally I lecture on judgment writing, and one of my top 10 tips is headings, and that's for judgments. I know, but it's the only way you can make sense of it. So ground one of cross appeal is my heading. Away you go.
But before, this is a 1 second response, which is my lady Justice Whipple asked about the pre-action protocol and the request for information, and the protocol itself at paragraph 13 talks about request for information, the purpose of which is to understand why the challenge decision has been taken, or present the claim in a manner that properly identifies the issues, and the defendant should comply with any request which meets those requirements unless there is no good reason to do so. So that's what the protocol itself says. And then on just factually...
That was your solicitors drafting the protocol letter. That's law stop saying we'd like some documents. You very often do in the PAP letter. I mean, it's absolutely standard to say
But the protocol, the actual pre-action protocol itself says that the defendant should
flag up any documents that they want to see.
Any documents.
Yep,
and then secondly, the disclosure application was made together when my Lord Junior, who no longer is in this case, issued the claim and made the disclosure application, which resulted in a specific disclosure order that you haven't been taken to, but made by Mr Justice Julian Knowles. So that's just for your background to answer one of the queries you have actually. Just on the cross appeal, ground one, as I said earlier this morning, this assumes that the duty arose and it was correctly identified. And so I'm not going to respond to the case that the duty never arose. So if it did arose as a matter of public law, it needs to be complied with. And the starting point, that is the starting point of the approach taken by this court in Re B, where there is a duty. The court then went on to say, well, how should we make sense of the local authority's actions, not how the local authority dresses it up as. And it matters not in Re B that it was a child in a private fostering arrangement. In fact, they didn't call it private fostering. It was a private family arrangement. The focus of this court in that case was what did the local authority did as soon as a duty arose? Did they facilitating the placement of the child with the brother DB? Instead of it being called a private arrangement as characterised by the local authority, this court made the finding that actually what they were doing, because a duty had arisen, that needs to be deemed to be a Section 20 performance. That is also how the courts have dealt with the structure of these types of cases. So you've seen that in G and Southwark and other cases where the court first identifies, at the moment in time claimed, did the qualifying condition for the duty under Section 20 arise? Answer, yes. Then look at, well, what is it that they did at that point in time? In G and Southwark, for example, they had put him in a bed and breakfast. And so, although they called it a housing bed and breakfast, a Section 17 bed and breakfast, it was actually deemed to be a Section 20. In L in Nottinghamshire, it was a travel lodge. In C, and Knowsley, in A in Coventry, both children were already in a private arrangement, and what the court did was say, well, the duty arose on this date, and from that point on, they knew she was there, and they allowed her to stay whilst they made further inquiries. So that is the approach. The structure is, did the qualifying conditions get met? And once that happened, the court is required then to look at the local authority's actions, not just at how they characterise it, but what that meant from a legal point of view and apply the law to the facts. In terms of the suggestion that Kay's a placement, well, it's just a placement that he wants to be in. Your lordships and ladyship have unfortunately obviously not been taken to any of the other provisions of the Section 22 of the Children Act. But when the duty arises under 22C,
there's a sort of order in which the local authority has to consider
yes,
options, starting with parents,
starting with parents, then with the family, relatives, other things, and then there also is a catch-all, which is such appropriate placement as may be deemed fit. To be more precise, it is the most appropriate placement available. So it's not the most appropriate placement forever. It's at that point in time, if it's needed, what is the most appropriate placement available? And all of the guidance and all of the cases will say, well, it's not that doesn't have to be the be or end all. You can move the child to another placement on assessment, on care planning, and the care planning, placement and case review regulations are extensive and talk about reviewing the placement itself, the suitability of placement over time. So case placement, if you look at this in
is capable of falling
is
within
capable
that
of
category.
being a section 22C subsection 5 placement. Just the reference for your lordships and your ladyships, the provision itself is at page 12 of the authority bundle, volume 1, tab 1. So we say simply, our point on cross appeal is not a quarrel with Surrey. Our point is, well, the judge made the finding that he did. He then erred in not treating that, everything that happened, all the steps that happened, the placement, the accommodation, leaving him with K, all of that as part of the Section 20 compliance.
Hence 13th of September.
Hence 18th of September.
18.
And that's the long and short of our cross appeal, which is why it doesn't have a lot of heavy facts. And if, as I said,
well, it does have heavy fact, but the heavy facts already in play.
Had already been done.
Yeah.
The heavy lifting had already been done.
Yeah.
But also the implication of Surrey's submission that you can have a duty met hypothetically and never perform is precisely the criticism made in Re B at paragraph 57 that I took you to earlier about, well, if you have a duty that you do not comply with, and therefore it means that the child never accrues any rights whatsoever, that positively cannot be the purpose of the legislative scheme, because that child is in need, prevented from returning home, requiring accommodation. And it would fundamentally, if the court allows that to be the case, that would fundamentally undermine the legislative purpose of the Children Act, and that's the final point we make in our cross appeal in our skeleton argument.
Isn't that why you have the discretion, though, to deal with cases where you might find there's a duty but there's been no performance? Isn't that precisely why the discretion is there?
That's retrospective, but for the local authority, they have an ongoing. For the local authority, you can't just say, well, we'll just worry about whether or not they ever come back to us and make that request. We can just have the duty arise, just don't do anything.
But that presupposes that they're accepting that the duty has arisen. I appreciate ground one of the cross appeal operates on the assumption that they did, but at the time, rightly or wrongly, they thought it didn't.
Yes, but Mike, I'm only addressing you on the cross appeal, not traversing the.
No, I understand that, but I just we would have to then look at it. Hence, my lady's question.
Absolutely.
I think
yes,
we'd have to look at it through the lens of the local authority, who didn't think that a duty arose. They may get to the position, not this case, but a local authority may get to the position. Well, we mucked that up. There was a duty. We didn't perform it. But there's a discretion,
and that's a discretion,
and so that would then be a discretion point.
In those circumstances, that would be a discretion. But as a matter of a principle of law, the duty arising and performance ought to go hand in hand with each other, because it will otherwise undermine the whole purpose.
That's I think what I'm questioning.
Yes,
I'm a bit troubled. I understand that if there's a duty, there's a duty. I just don't think I follow the idea that the moment you've got a duty, you almost necessarily have performance. So you look around to see what they actually did and you attach the label of performance to what in fact happened, because that seems very contrived to me, because you may have a situation where the duty has arisen, but the very breach you're complaining of is the local authorities didn't do the thing they ought to have done. And that's when you...
And that oftentimes, there are cases where the duty has arisen, there's no dispute about that, and there's a discrete performance challenge. In Marie B, part of that was, well, the duty did arise, but the local authority's position is, well, the duties arise, but it didn't need to be performed. So that was their view, that it didn't need to be performed.
Well, would that be what they would say, or would they not say, we're not under a duty? Would they not say,
Well, either if you are under a duty, so I'm only talking about a scenario where it's not whether you have a duty, but...
So we've established that there's a duty, but there's an issue over performance.
Yes.
And it feels to me like there are lots of different sorts of cases out here. One rule is probably not going to fit all of them because you have to look at what actually happens. But I'm uncomfortable with the idea, as you say, that... I'm uncomfortable with the idea that the moment you have a duty, you axiomatically must have performance of that duty, because the whole point is that might be the failure. Then the duty was not performed. And as I've understood it, performance is very relevant when you come to categorisation, what sort of child you've got, eligible or qualifying, and all that stuff.
And
that's where it really comes in.
And that's
primarily.
why, in the imam context, where they says, well, a duty arising, the expectation is that you need to...
Yeah, you'll fulfil it. And that is the general
fulfill
idea.
it, right?
Yeah.
So that is the general concept, is that a duty arises, you got to get to the end result of what that duty requires you to do. That might take 24 hours, it might take 4 days, it might
But there must be a class of cases where the duty arises and the local authority doesn't fulfil the duty.
Yes.
That's the breach.
And there are those cases where a judicial review challenge would then be brought on that basis.
yes.
I'm not saying that isn't that challenge, but I'm just saying as a matter of conceptually, here obviously we've got a situation where the judge has made a finding that on this date this thing happened, but it didn't then get performed until the 17th of October. Perhaps I don't need to torture myself on this because I can rely on C and A to say, well, in those cases where there had been a pre-existing private arrangement, the court decided that Section 20 arose, and then the local authority allowed the child to remain in that type of accommodation as part of a discharge well within the scope of Section 22 and 22C.
Can I try
that could
another...
potentially be a way of doing it. And can I just make one last point, is that I took you to 57 of Re B, which is the passage where if you don't do, can you just do nothing after Section 20 arises? And this court said, well, that would undermine the policy, public policy imperative of ensuring that the person who you've decided requires accommodation because they're in need gets there.
Can I suggest, and you'll shoot me down if I'm talking nonsense.
I wouldn't dare.
Well, if I am, you would say so. Once the Section 20 duty arises, is it arguable that the way you look at it is the court then has to consider, the local authority then has to consider its duties under 22C?
Yes.
Under 22C, the local authority, first of all, must make arrangements under Section 22C2 for the child to live with the people in
Listed there.
one of the categories in subsection 3, parent, someone with PR, and the other category, if the child's in care. And then, if that doesn't apply, under 22.5, it must place the child with a placement which is, in their opinion, the most appropriate placement available. So that's the duty. And the placement under 22.5 means one of the 4 categories in 22C6.
Yes. And then there's, I'm afraid,
none of this is in the judgment. None of this is in the judgment.
Well, because the judge found that no duty arose and no performance arose until the 17th of October.
But then.
But he does look at.
But performance, whenever it arises, on this basis, you say you look at 22C.
Yes.
And where's that in the judgment?
He doesn't make an express reference to Section 22C in the body of the judgment, but then he looks at the scheme at paragraph 12, and I accept he doesn't specifically look at section 22 capital C, but the material was put before him. You know, section 22C was before the judge. It's a type of accommodation. It wasn't an argument about the type of accommodation when it came to the 17th of October. It was reliance on C and Coventry, C and Knowsley, A and Coventry. The local authority allowed the child to stay at K's, pending other investigation. You can, because in both of those cases, the pre-existing arrangement was then treated as a Section 20 placement. I'm just pointing out, because my learned friend does make the point that case placement is just case place, but that it is the point is that it's capable of being a Section 22C.
Yes.
I would accept myself. I would absolutely accept that a placement with K's mother could have been the most appropriate placement available. But the trouble, and it may just be I need to go over the papers again and think about it a bit harder. If the local authority had said to itself at some point in September, we have a duty under Section 20, they could then have thought about it.
I accept that is the issue on the appeal.
Yep.
I know there is sometimes, because my learned friend has dealt with the appeal and the cross appeal together, I'm only focusing on assuming she's wrong and I'm right in relation to the duty arising.
And again, it may just be splitting hair, and it may be that it's getting late, but there's a difference between the lawyers after the event in court finding that there was a Section 20 duty and the situation where at the time the local authority recognises the Section 20 duty.
But I am not saying that this court should make that finding. I'm saying this court should make the finding that the judge erred in not considering that issue. So it's again what I was trying to say earlier, which is, you know, the judge, you're not making a finding that it was irrational or rational that the local authority did X, Y, or Z. You're making a finding whether the judge was right or wrong, or failed to consider fundamentally the right question, or ask the right question, or consider the right factors in relation to coming to the judgment he did, unless he obviously trespassed into substituting his view for the local authority's view, which I can see, you know, that would be an error.
I mean, I know you're only responding
Yes.
quickly to one point, but I just wonder whether, in fact, the answer is, as I suggested, in 22C rather than in 20. In other words, once the duty under 20 has arisen, then the local authority has a separate, a new statutory duty to place the child
In
the placement, and the bottom line of which is under 22C5, which is in their opinion the most appropriate placement available. And that, of course, that is flexible enough to accommodate a short-term decision.
Of course.
We don't know what we're going to do. Looks all right with Kay's mum. Keep him there for the moment while we go and do a bit more thinking.
Yes.
But that's how it might be structured. Okay.
Yes.
Thank you.
And I will hopefully now be able to sit down unless
So that's ground one and ground two of the cross appeal, Mr. Clark.
Yes, my lord. 3 points in response. I'm not sure the first makes it to the status of a full heading. First point is that my learned friend, in her response, essentially relied on paragraph 35 of the statement of Miss Andrews, saying there's no benefit to him now in getting it because he's over 21. My first point is that none of the points made against me in that respect were anywhere in my learned friend's response to the appeal. So I'm having to deal with these slightly on the hoof, and there is an extent. There's a question about the extent to which she's entitled to take those points, not having set them out anywhere previously.
This is the Wild West of the administrative court. Nothing is ever fully set out, and nobody ever ultimately nails any colours to any marks.
It's not the disciplined environment of the family court.
Okay, so that didn't make it to a full heading.
I'm very comfortable in this world.
Yeah.
Oh, so am I, because it adds to the gaiety of nations, as Lord Justice Christopher Clark once said. But I think we're here to try and reach the right answer.
Yes, well, no, I would only perhaps ask that some that in considering my responses, the fact that they're thought of on my feet in circumstances where they weren't raised before my learner's friend's oral submissions is a matter that should be taken in my favour.
You all remember what fun it was, Mr.
Yes,
Wright.
exactly.
That's not a joke, it is fun.
So that's the first point.
The first point. Second point is essentially picking up the point made by my Lady Justice Whipple, that it would fall for consideration as at the point after this court's judgment in light of the circumstances, and that developing from that, and there are two references that I'll give you. First, it would depend on the degree of unlawfulness found by this court. So in HP, paragraph 23, Roman 10 to Roman 11, that's second volume of the authorities, page 599.
Sorry, this is the first time we've referred to that.
No, we went to HP.
Sorry? HP.
What's the page?
599.
HP and who?
And Greenwich.
It's
It's the second of the two authorities that I looked at previously. It's
It's
a
Greenwich.
very long exposition of principles by Mr Justice Fordham.
Yeah.
And it's one which now becomes relevant, which is Roman 10, Roman 11, that the degree to which the relevantly
Sorry,
flawed...
which paragraph are we in?
So it's paragraph 23.
23, I've got it.
You won't see that on that page. I
Yeah.
think it's a couple of pages before. The degree to which the relevantly flawed age or needs assessment stands to be criticised, including by reference to the degree of fault or blameworthiness, is a relevant consideration. And then a similar point made in Roman 11. And that is a matter, obviously, that can only be determined in circumstances where one has the decision of the court. And we saw, I took the court to a similar point made in GE, that you couldn't even necessarily be expected to request exercise of the discretion until the unlawfulness has been established. But yeah, certainly Ms Andrews' assessment of the position back in August 2023 may not constitute a full consideration of the discretion in circumstances where subsequently we've had a decision of the High Court and we'll have a decision of this court.
But you say there's something in it even now, do you? Because he must be must be well beyond 21 now.
Well, yeah, that's going to be...
That's what you're coming to that.
That's point 3
Yes,
of my 3 points. Just to finish off on point 2, so the first thing that would need to be considered at the actual date of exercise of discretion is the degree of unlawfulness found by the High Court and this court, if it does. And the second is the needs at the date of consideration, and this leads into the point my lady makes. So that's HP at paragraph 30.
These paragraphs aren't dealing with the possibility of a future claim. They're talking about the discretionary, the exercise of the discretionary power, and whether relevant propositions being the degree of culpability or blameworthiness.
Yeah, so...
But you can't say, well, we've got to wait for a decision on it before we know whether we can re-ask for an exercise of discretion.
It's perhaps illustrated by the factual differences between GE and HP.
Is there an authority in which, having raised the question of discretion in the original claim, that the ruling has been that you go back and can ask for it again?
So in GE, the paragraph to which I took the court earlier was, hang on, one moment. So 71 is the paragraph that I took the court to earlier. In GE, the situation was that the challenge to the age assessment was brought with also seeking a declaration in relation to exercise of discretion.
Yeah.
And so here the court, in fact, sent back to the admin court the question of what her true age was.
Well, of course.
And then
that's what happens in those cases, because this court can't decide that.
Yes.
But what I'm simply looking at is whether it is appropriate for an issue which has been raised here to be the subject of a further claim.
I'm not sure I understand the question, my lord.
You've raised this.
Yes.
Will decided. How could there be? Where could there be any ground for saying, well, it should go back to Surrey?
Because
why isn't it raised judicata?
In relation to the discretion point.
Yeah.
Well, because if the relief that were granted was a quashing of the decision not to exercise the discretion, then the Surrey would be in a...
What is it if the relief is the claim fails? You've demonstrated that this claim was raised as part of these proceedings. So if the appeal was allowed and the claim failed, then there wouldn't be any grounds for going back.
Yes, my lord. I'm saying if the appeal's not allowed, so the court still says that there's a discretion to be exercised, and that Surrey hasn't given lawful consideration to the exercise of discretion, then it will now have to do so in light of all the facts as exist.
All right, so this is dependent on a finding that there hasn't been an exercise of discretion.
Your case is there has, isn't it? Your case is that
it
was decided.
It was essentially an unreasoned decision.
That is your case.
Yes.
Your case was it was decided against you.
Yes.
The case that's now put on the other side is there was no decision.
Yes.
And it's your answer to that case, isn't it? To say, oh well, if there was no decision, we'd still like one now. Is that right? Have I got the sequence right?
So yeah. So what was being asked of the judge below was to decide that the effectively
there was a wrongful refusal. That was
the unreasoned refusal. But if in fact what you have is not an unreasoned refusal but no decision at all, it doesn't seem to me that that's a terribly helpful answer to Surrey to say, well, we've just never made a decision on it because.
Well, if that's the truth of it, they say we've never made a decision on discretion because nobody ever asked us to, and we didn't see that it arose because we never thought we had a duty. And we now say, well, we think there was a Section 20 duty, which was never implemented or whatever. So you get to the discretionary point. I think it's your answer, isn't it, to say, well, if that's where we are, we'd like it now, please. And I don't know if that might be right or wrong. I'm just trying to.
Yes, the request effectively has never been determined.
Contrary to your primary case.
Yeah. Well, yes. Either the request has been determined poorly, and the judge should have held that had he gone on to consider the issue, or in fact it's never been determined. In which case it should be determined now. But in either of those cases, it would have to be determined on the basis of the facts that exist now, not and this court's judgment and whatever needs BC might have now, not the position as Miss Andrews saw it in 2023. Mm-hmm. And then the final point is picking up on the point about him being over 21 now. I think my learned friend said that over 21, the duties only exist if you're following a course of education or training that is set out in your pathway plan, and he doesn't have a pathway plan. That was the original position under Section 23C7 when 23C was enacted. But the Children Act, as you'll know, has been successively amended time after time. So if you look at page 22 in the authorities book.
22C didn't exist.
Sorry, 23C is the
22C.
22C.
No, 23 we're on now. The duties to former relevant children.
Okay, fine.
The 23C was the first set of duties that was introduced for former relevant children. And my learned friend is right that in 23C7 it says the duties continue to 25 if you're following training in your pathway plan. But then at page 22 you have section 23CA.
Yes.
This was inserted by the Children and Young Persons Act 2008. And you'll see 23CA1, this section applies to a person if he's under the age of 25, he's a former relevant child, towards whom the duties in 23CA no longer exist because he's over 21.
I'm on 23C, I've got myself that far.
Sorry, 23CA, my lady. Page
Capital C, capital A.
Yes, sorry.
You're lucky it's not a Z.
Well, there are Zs.
There are Zs.
I have got there.
Page 22 of the authorities bundle.
This is how the parliamentary draftsmen earn their corn.
Yeah, no, I should have been, sorry, that was entirely my mistake. 23CA, I'm there.
Yes. So if you're under the age of 25, you're a former relevant child to whom the 23C duties have ended because you're over 21, but you inform the responsible local authority that you're pursuing or wish to pursue a programme of educational training, then it's the duty to provide a personal advisor, it's the duty, subsection 3, to produce an assessment of needs and a pathway plan, and then to give, subsection 4, duty to give assistance of the kind referred to in 5 to the extent that your educational training needs require it. That's the need. Then there is also, I'm afraid, this isn't in the bundle because this wasn't directly an issue before my Lynn and Friends oral submissions, 23CZB, which was introduced by the 2017 Children and Social Work Act. I've got copies because when I was going to do it,
I've got the red book. I knew it would arise sooner or later.
Well, I'm hoping that this would have, or this will be in
the joint note.
summary, the joint note that identifies the categories.
Precisely.
And effectively, without wishing to be too mercenary about it, but what you get up to what age in which category.
Yeah,
Precisely.
that is what I was hoping for at the start, and I think
Yes,
my hopes have been.
I'm afraid I didn't have time to do it, but we will now do it. We will now do it in a note.
Your hopes are going to be fulfilled by a note without any argument at all, but simply setting out how that works in terms of the different categories of child or former child, young person, sorry, and the what they get. So
I mean, I could do it for myself, but I think it will be helpful to have it.
Absolutely.
I mean, these provisions are extraordinary.
Yes, every time I have a case that involves them,
So do I.
have to go through.
There's a 22ZZA introduced before 22ZA and ZB.
And if you go to
and then there's
Westlaw
23. Then there's 20. So that's 23, and then there's 23A, B, and C. There's 20. But 23, section 23, the original section 23, has gone. That was repealed.
Yeah, I mean it is extraordinary, but I think the point for present purposes is that even looking just at CA, I've showed that the duties don't end at 21, so it's simply not right to say once you turn 21 it's all irrelevant. And
what's happened here is that Parliament, in a succession of reforms, long after the introduction of the Children Act, has introduced incrementally more provision for so-called care leavers and vulnerable young people in this position.
Absolutely. And so once upon a time it might have been an answer to say he's over 21 now, but it just isn't anymore. And final point to finish off on that.
And what is the date by which you measure age? So you took us to 23CA. This section applies to a person if he is under the age of 25.
Yes.
At what date?
At the date on which he informs the local. So, if you turn up to the local authority and you're a former relevant child, and you say that you want to pursue education,
the day
if
before
at that
your
date you're 25,
day before your 25th birthday.
Then,
so it's the date of the.
If those three conditions are met at any given date, then the duty arises. It may be that if you're 2 days before your 25th birthday, there's no point because the duty will be very short.
Would it be?
Outdated.
If the applicant applies 2 days before, and he says, "I wish to pursue an 8-year programme of language study at the Sorbonne,"
it would be the date on which you turn up. But yeah, you're right that it's the extent of the programme.
Yeah.
So, yes, the duty to prepare the pathway plan, and then if that pathway plan includes a course of education, then it's the duties under the section.
So it's it can, as my lord says, be.
Yes.
It could be medical school.
Yes. If that's what is rationally assessed as being part of your plan. Yes. And so effectively that used to be the position with 21 as the cut-off under 23C7, and now it's the position with that under 20 with 25 as the cut-off under 23CA, albeit with a slightly lower level of duty. the final point.
Pause, I'm about to lose it again. 23C
Sorry,
talks
23C.
about former relevant child,
Yes.
but on this hypothesis, I think we're talking about a discretionary exercise because how do we fit this in with the case that says this was not a former relevant child because there was never any execution or implementation of a duty by prison? So
my case,
qualifying.
just on ground two of the cross appeal, is use your discretion to put me in the position that I would be had I become a former relevant child. Many years ago, that position would have been less advantageous. Now, the position that I would be in as a former relevant child includes 23CA, 23C.
There's another layer on the discretion.
Yes, I mean it just means that if they exercise that discretion to treat you as a former relevant child, you get more for it.
Yep.
And
Even if at the time when you were or would have been under the beneficiary of the duty which subsequently led you to being a former relevant child, the consequences were less.
Yes,
stark.
that's because
That's
that
the way
would be
Parliament works.
And
Parliament has made it. The statute works.
Because had you actually become a former relevant child, you would have benefited from the expansion of those duties as you got older. And so, why should you be in any less good position because they failed to make you a former relevant child?
Yep, thank you.
Very final point is just to say that the statement of Miss Andrews wasn't the end of the evidential position. You'll see in the supplementary bundle there's a witness statement from BC himself, dated the 25th of August, 2023, begins at supplementary 184, but then from 195 to 197, there is a section headed "My current circumstances and why being recognised as a former relevant child will now make a difference to me," and that includes his wish to go back into education, etc. So the duties under CA are not hypothetical; they're ones which would really be engaged in this case.
Mm-hmm.
Are there any further questions on that ground that I can assist with? I'm sure the note will be an assistance that turns into a much bigger task.
I was going to say, Ms. Rowlands, the position is that, excuse me, whilst ordinarily I might have got you to deal with 23CA, because you haven't addressed that, but am I right to hope that can be in the note dealing with the
Yes. I have got in front of me a table which sets out the 4 categories: eligible, relevant, former relevant and qualifying, the criteria for them, where those criteria come from, and a brief note of what they get. Ms Andrews reminded me at lunchtime that the Care Act Guidance Volume 3 also has a useful table that sets out...
We'd like something, we would be much happier after these 2 days having something prepared by the 3 of you. I may draw on that, but something prepared by the 3 of you, because it shouldn't be in dispute. It's really saving us from spending a week trying to work out the different statutory provisions.
I would agree that for a former relevant child, it goes on to 25, but for a qualifying young person, 21 is the cut-off unless you have been.
Okay, well, there you can. That's why I said let's have it in the table, because I thought there would be a difference, because former relevant child seems to be the jackpot position, and qualifying young person seems to be the £2.60 on the Euro Millions. I mean, I'm sure it's not quite like that, but you know what I mean. Okay.
There was one other thing, 22C. May I please respond on that one, because that is something I haven't managed to address before.
Well, my lord has raised 22C.
Yes. And suggested that placing BC with Kay's mother might be performance under 22C5. But I'm afraid that doesn't fly, because 22C6 says it has to be someone who is approved as a foster carer by the local authority.
Okay, well, I haven't got that. So,
Page 12
Page 12.
of the...
20, I was on something else.
Ways in which looked after children are to be accommodated and maintained. So if the local authority, the first port of call is to place
parental responsibility.
Parents, someone with parental responsibility, or someone with whom
If you're in care.
formal care order was made. Then, if they can't manage that, the placement which is the most appropriate placement available, placement means a placement with an individual who is a relative friend of other person connected with the and who is also a local authority foster parent. Or another foster parent, or children's home, or other arrangements which comply with regulations. The point is, of course, you're placing a child with somebody. A foster parent is trained, regulated and supervised. This is a local authority performing its duties as a statutory care function, and the suggestion that just leaving him with someone who's a friend complies with that kind of necessity it is quite a scary one in my submission. Accidentally putting the local authority in the position of performing Section 20 by leaving them with a friend that they've made that arrangement with, where that friend is not a foster parent, then also implies all the panoply of Section 20, the pathway plan, the assessments of needs, the maintenance and so on and so forth. And it's quite a big undertaking, and that's why you have the requirement that it be, if a relative, friend or other person connected with C, it be someone who is a local authority foster carer and approved, regulated, insured, all those sorts of things that go along with that. So, my lord, I don't think your suggestion gets off the ground, I'm afraid.
And in that case, what is the position? The local authority says we're under a duty under Section 20. What if they think the best person? If they decided we were under a duty under Section 20, but they thought the child should remain with Kay's mum, what does it then do?
Well, they could ask her to step up and be approved as a foster carer. She'd have to make sure that she was doing training, but she would then be entitled to a foster allowance, so there would be a big incentive for her to do so.
But if she says no, what happens then? You reconsider whether there's a Section 20 duty at all, because you say to yourself, the child is reasonably accommodated and we don't need to go there, or how does that all work? Or you say you can't stay with Kay's mum because there is a Section 20 duty and we've got to put you with a foster carer. And that's how it goes.
Yeah, that would have to be the case. I mean, in those circumstances, the local authority would have to say, we have got a duty, we accept that there's a duty, we have got to perform the duty, and we can only do it in one of the ways set out in 22C. I would imagine that in these circumstances, a bit more effort would have been put into mediation with mum and getting him back into the family home as being top of the pecking order there.
Okay.
But we're
go on, I shall keep on making more suggestions.
We're flying down hypotheticals here, and what actually happened was BC had already sorted himself out and Surrey were not performing a duty under Section 20.
Well, we understand that, but the question of hypotheticals may matter.
I mean, I'll say what I was going to say, which is the would you argue then that what was happening here was, in fact, an arrangement had been reached between the individuals concerned, so that the duty under 20 didn't apply? That's your case, isn't it?
I think the arrangement was
the other way around. You say there wasn't a Section 20 duty.
There wasn't a Section 20.
There wasn't a Section 22C
because the parties had reached an arrangement had been made.
Basically, he was a lodger. I mean, that was the arrangement. And that was an arrangement that he was perfectly entitled to reach for himself, and one that he was perfectly happy with.
But it's not, I don't know, I mean, isn't that putting it slightly the wrong way round? Going back to our earlier discussion just a minute or two ago, that the fact that he was a lodger was a permissible arrangement for the local authority to be aware of because there wasn't a Section 20 duty, so it didn't have to intervene in any more substantial way.
Didn't require accommodation. He wasn't a child in need of accommodation because he got the lodging arrangement.
Yeah.
He could have moved in with his wife and 3 children by that stage and had accommodation in his own right. But as it happened, he was a 17-year-old, nearly 18-year-old lodger going out to work, earning money to pay for his board and lodging. Or not, as the case may be in this case, but that was between him and his landlord.
It falls back on your case that he wasn't a child in need and Section 22 didn't arise.
Exactly.
Lord, I'm not going to do much more than to say that subsection 6 of 22C also includes a catch-all provision where, subject to regulations, a placement under section 22C5 could be something else subject to regulations. So we will include that in any...
Yes, subject to regulations. Yeah.
So that's all I wanted to flag, but we will ensure that any relevant provisions that would assist your lordship and your ladyship are included in that joint note.
Right. Anything more?
No, thank you.
No. Right. That's it. We don't have any more questions for you. Thank you both very much. Thank you to those of you sitting behind you. This is not a straightforward case, and we've been greatly assisted by your submissions. Thank you, all three of you, very much. You'll be unsurprised to learn that we're going to reserve our judgments, and we'll obviously endeavour to get them to you as soon as we can, but we can't promise when that will be. The judgments will come to you in draft. That's an opportunity to correct our typos and our grammar, but not an opportunity to re-argue the case. At the same time as sending you the draft judgments, we would ask you, and it ought to be clear from the judgment, to agree an order. But sometimes it's not possible, we understand that. Sometimes there's one point outstanding, whatever it is. When that happens, if that happens, the best way of dealing with that is to have a composite order with all the stuff that's agreed and the two bits that aren't agreed in square brackets. I had one yesterday, one red, one green. It made it very easy to work out what the points were, and very short written submissions on what the differences are, and we'll decide that on paper. The judgment, when you get it in draft, is obviously for the eyes only of the people on the list that's been sent to us, but of course for the limited purposes set out in the Counsel General of Wales case, you can talk to your clients about it, but only for those limited purposes. The judgments are confidential until they're published, and as you both, all three of you, will know, it is a contempt of court if they are published beyond the people on the list. So that's a warning I'm duty bound to give you. I know you know all this, but I'm duty bound to give it to you. We will then hand down the corrected judgment electronically, so there won't be any need to attend, and at the same time, we hope we'll be able to decide what should and shouldn't be in the order, and so there can then be a final version of the agreed order, and it doesn't matter if that takes a day or two longer than the hand down of the judgment, but it's best for everybody, including us, that we do both the judgment and the order, at least in the same narrow time bracket. Okay, I think that's everything. Thank you all very much.